Hi, my name is Anisa Jordan of the Jordan Law Firm. I primarily practice in the area of criminal, DUI, and traffic law. And today we're going to talk about the petition to rescind a statutory summary suspension when your client is arrested for a DUI. So as I mentioned, we're going to talk today about a petition to rescind a statutory summary suspension. But the first question that I want to answer for you today is, what is a statutory summary suspension? Anytime an individual is arrested for driving under the influence of alcohol or some other drug or compound, their license will be suspended by the Secretary of State. That suspension will last anywhere from 6 months to 3 years, and that time frame depends on their background as well as whether or not they decided to submit to a breathalyzer. You can challenge that statutory summary suspension in court. So once your license or your client's license is suspended, you can challenge it through a petition to rescind the statutory summary suspension. That's done in the courthouse. There are 5 grounds under which you can challenge that suspension. The first ground is that I was not properly given a ticket for driving under the influence of alcohol. The second ground is that the officer did not have reasonable grounds to believe that I was driving under the influence of alcohol. The third statutory ground is that I was not properly read my warning to motorists. The fourth ground is that I did not refuse to submit to a breathalyzer. And the fifth is that, yes, I did submit to chemical testing. However, it did not show that my alcohol concentration was over 0.08. Now, you have to keep in mind there are very specific timing guidelines in which you have to file your petition to rescind the statutory summary suspension. Once you file that statutory summary suspension, the state must give you a hearing within 30 days or the very first court date. If they do not give you that hearing, then the suspension could be rescinded and your client may get his or her driver's license back. Secondly, you also have to file that petition to rescind within 90 days of the notice of statutory summary suspension. Now, this comes into play a lot of times where you may have a client who has gone a couple of court dates without legal counsel, and by the time you come into the case, that time period has already passed. So that's something that you definitely want to check for when you first take on the case. Some things you want to keep in mind with the petition to rescind is that it's civil in nature. So although it is attached to the criminal offense of DUI, it is governed by the rules of civil procedure. So you have options to file a motion to produce with respect to a petition to rescind. You also can file a motion to omit facts. Another thing you want to take into consideration is that you are going to have the burden of proof with the petition to rescind. So in the criminal DUI, it is the state, but in this portion of the case, you have the burden. For more information on statutory summary suspensions, be sure to check out the ISBA book, DUI and Traffic-Related Decisions, which is available on the ISBA's online bookstore. And to learn more about the benefits of joining our ISBA Traffic Law and Courts section, check out the ISBA website. Thanks for watching.